Good afternoon. My name is Doreen Hartwell, and I am an attorney in Las Vegas, Nevada.
Good afternoon. My name is Steve Jewett. I'm a county court judge in the Ninth Judicial Circuit of Florida, which is Orlando, Orange County.
Good afternoon, Colorado. I am Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals, which is Oregon's Intermediate Appellate Court. Looking forward to hearing you this afternoon.
Yes. And you may introduce yourselves.
Hi, my name is Rain Watt, and I'm a junior.
Hi, my name is Jackson Sharp, and I'm a junior.
My name is Ruby Stevens, and I'm a junior.
My name is Scarlett Pryther, and I'm a junior.
My name is Jude Wolf, and I'm a junior. And our teachers are Mandy Hossetter and Matthew Fulford.
Okay. So the question that we're asking today or this afternoon is question number 2. And it reads, a quote from Thomas Jefferson: "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference." Do you agree or disagree with Thomas Jefferson? Additionally, what are the advantages and disadvantages of a national bill, of rights as compared to state bills of rights? And finally, what are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
The framers clashed over how to best protect individual liberties. Anti-federalists claim that fundamental rights must be explicitly protected in a national Bill of Rights. But in Federalist 84, Hamilton argued that a Bill of Rights was not only unnecessary, since Congress lacked the powers to deny essential rights, but dangerous, because unenumerated rights could be denied. Jefferson, an anti-federalist, was correct that no legitimate government would allow protected rights to be only inferred, rather than explicitly stated. Jefferson, like Locke and other Enlightenment thinkers, posited that not only does the ultimate authority rest in the people, not God, but that governments derive their authority from the consent of the people. As a consequence, a just government must recognize the liberties of the governed.
Barron v. Baltimore, 1833, ruled that the Bill of Rights does not apply to state governments. But following the Civil War and a major restructuring of our federalist system, the 14th Amendment Due Process Clause allowed the federal government to protect individual rights from intrusion by the states themselves. U.S. v. Cruikshank, 1876. Selective incorporation expanded and defined federal protection of rights against the states, beginning with Gitlow v. New York, 1925, which specifically incorporated freedom of speech and press. But certain individual rights that are not explicitly upheld in the Bill of Rights, like the right to vote, are arguably also protected by the doctrine of preemption, a concept derived from the Article 6 Supremacy Clause, which holds that federal law may overrule conflicting state law, Gibbons v. Ogden, 1824.
But states also play an important role in protecting individual rights, including under their own bills of rights. Under the 10th Amendment, states retain powers not granted to the federal government and may enforce important rights that are not secured in the federal Constitution, such as the right to an education. Laboratories of democracy are active examples of how progressive local legislation or unique state bills of rights can affect federal rights. Recognized by Justice Brandeis and New State Ice-Co v. Liebman, they enhance the idea that each state can try novel social and economic experiments without risk to the rest of the country. Colorado led in legalizing marijuana, and Massachusetts led in guaranteeing health care, which the federal government followed with the Affordable Care Act.
State Bill of Rights are easier to amend and can adapt to changing times and needs more quickly. For example, the Nevada Bill of Rights explicitly enumerates 10 protected categories of people, while the 15th Amendment only names 3. Both State Bill of Rights and Federal Bill of Rights are crucial to the protection of our rights, although only a Federal Bill of Rights can protect individuals from intrusion by the states. States can, unfortunately, also be laboratories for discrimination. Negative rights prevent government infringement on rights, while positive rights require government action to ensure rights. Notable negative rights include the right to habeas corpus and the free exercise clause. Positive rights are more nuanced and include the right to an attorney and trial by jury. Negative and positive rights both can be implicated at the same time. As an example, the 14th Amendment is written as a negative right, but is used to enforce and protect both positive and negative rights in the state constitutions.
While negative rights have played a critical role in securing liberty in the past, positive rights play a unique role in guaranteeing liberty now and in the future. Article 1, Section 4 delegates elections to the states. The 15th Amendment, though not technically a positive right, paved the way for the Voting Rights Act of 1965, which required jurisdictions with a history of voter suppression to seek preclearance before implementing voting changes. Following the ruling of Shelby County v. Holder, 2013, states began to pass some of the most oppressive voting laws since the era of Jim Crow, showing that voting rights must also be ensured as a positive right for them to be preserved. Fighting for liberty is a uniquely American endeavor. JFK said it best. The cost of freedom is always high, but Americans have always paid it. We are now open for questions.
What limits, if any, should be placed on rights listed in the Bill of Rights?
When a Bill of Rights, when an amendment right such as the right to free exercise comes into contact with a state regulation, the court often uses strict scrutiny, and the limits are usually a compelling state interest when infringing on someone's rights.
Yes, mainly they use the levels of scrutiny to determine how to best apply the Bill of Rights, including the rational basis, intermediate scrutiny, and strict scrutiny. But that's sort of the court's role to, the judicial branch's role is to interpret the Bill of Rights and apply it to the states.
And we're also seeing that more often than not, certain rights, especially in the Bill of Rights or just the amendments on whole, can almost limit each other because free exercise often comes into conflict with equal protection or due process.
You mentioned that the state Bill of Rights can be amended easier, so they're more nimble in that sense. But do you see a potential downside to that, to the ease of amendment?
Well, the framers were very careful in crafting our Constitution. And so in the ease of amending state Bill of Rights, there is definitely some downside to such as it can go against what the framers originally intended.
For example, when Colorado legalized marijuana, there wasn't a lot of structure following the enactment of that law. And so there had to be a lot of restructuring of what needed to happen following legalization.
And of course, there is somewhat of an inherent benefit because the state constitutions can change with the times. However, the Colorado Constitution has been amended 166 times, while the United States Constitution has only been amended 27 times, which just works to prove my colleague's point that a lot of the times things can get passed without the full legislative process being included.
And
Good,
Colorado,
Go ahead. Go ahead.
Just Colorado is a special case, especially considering the Taxpayers' Bill of Rights that poses strict limits on our state government's ability to raise taxes, but we also have very low thresholds for changing our Constitution.
Can you evaluate some of the pros and cons in terms of protecting positive rights in legislation versus a constitution?
Absolutely. With protecting positive rights in legislation, such as food programs or Section 8 housing in Colorado, that can allow governments to more easily adapt to changing problems over time. But of course, they can also run into discriminatory issues. When Bill Clinton passed laws denying public housing to drug offenders during the war on drugs, that was extremely egregious and wouldn't have happened if it was in the Bill of Rights or an amendment.
And going off of that, laboratories of discrimination are often played out in these legislation and in bills, such as the bills targeting transgender people in multiple states. There's 8 bills currently passed and over 100 trying to be passed.
Under what circumstances, if any, would cause a person to lose rights found in the Bill of Rights?
I think in situations of high crimes or specifically terrorism, I know there have been cases involving American citizens going overseas or committing acts of terror. And in those situations, they've lost some procedural due process rights.
And historically, we have seen the writ of habeas corpus by President Abraham Lincoln. And the habeas corpus is provided in Article 1, Section 9, but was eliminated during the Civil War by Abraham Lincoln.
And of course, due process. You need due process before the court, before the government denies you of life, liberty, or the pursuit of happiness or property.
In many states, if you're a convicted felon, you lose the right to vote. What do you think about that? And do you think that's appropriate?
Absolutely not. It's, I think especially state governments need to recognize that rehabilitation is always an option, and people, whether they commit a crime or not, have just as much of a right to determine what their government looks like. Also, it's incredibly dangerous because that's, I mean, yet another reason in the war on drugs to criminalize people to take away their power to vote or pursue housing. So it's not good.
And this just shows the need, the crucial need for a federal explicit right to vote, because currently they're mainly only enumerated in the states. New York just passed a bill restoring voting rights of felons on parole. And we just think there needs to be a national consistency.
And of course, convicted felons are still citizens of the country nonetheless. And when they are denied the right to vote, that goes against taxation without representation, which is one of the principles our country was founded on.
Do you think that there should, oh, go ahead, Ruby.
I was just going to mention that in the 2000 election, there was the potential for there to have been a different result to the election had the felons in Florida been able to vote, because the election was so split in that area of the country.
Thank you. Do you think that there should be any additional positive rights that should be added to the Bill of Rights?
Absolutely. We believe that there are many rights in the Universal Declaration of Human Rights by the UN that should be added to ours, such as the right to education, the right to healthcare, and the right to public assistance, federal assistance.
And the importance of education, it was argued in San Antonio School District that it was, and this was an argument that the court threw out, but I believe it's pretty valid nonetheless, that it's an almost prerequisite for exercising your constitutional rights. It's a lot easier to vote. It's a lot easier to protest, to request counsel if you receive education, specifically civic education. But more importantly, we think that there should be almost like shadow positive rights to further substantiate current negative rights, like the Voting Rights Act and preclearance. Oh, may I finish?
Yes.
Because we see that while negative rights provide immediate limitations on what government can and cannot do, over time, governments evolve to combat them. And so it's important that our rights evolve with them, like their positive rights.
Great, thank you.
Good job.
Stephen, would you like to go first?
Sure. I thought that the structure of your prepared statement was very good, and you took the questions and answered the things that were in there. And it does, when it's complete like that, it makes it difficult for us to have questions, because a lot of times some of the stuff we ask, you've already answered. So you made it harder for us. I've been asking mostly about the clash between a federal and a state Bill of Rights in their constitution. And I think, I asked you guys that question. I thought you did well with that, and indicating that there potentially could be problems. I mean, there's really two sides to it. The one side is that it can be quick, it can be nimble. Something comes up and it's a real problem, or something that the people want and the legislature won't do. It can happen. Of course, the flip side of that is that if it's too easy, then I think, did you say that the Colorado Constitution's been amended 167 times or something along those? That just on its face seems like too much. And I know in Florida, we have things in there that probably shouldn't be in the Constitution. You can't put a pig in a cage. And you would think that's something that's new. I mean, old, that's new. That was within like the last 10 years. But so that to me is a very interesting issue, and there's really not a direct, real answer to it, but I thought you guys handled it well. So thank you very much.
Great job. I appreciated your discussion of pre-14th Amendment history and the Bill of Rights not protecting people against the state governments, and it made me want to know more about the role the state constitutions played at that point in time. So excellent discussion of incorporation. I liked your concrete examples about how state constitutions can lead the way for the rest of the country. I heard you talk about the Affordable Care, or how the Massachusetts right to health care led to the Affordable Care Act, and certainly legalization of marijuana is something that is continuing to develop across the country, led by states like Colorado, and so I enjoyed that discussion in particular. So great. Oh, and the other thing I like, you have a very good understanding of the difference between legislation and constitution, and I thought evaluated the risks and benefits of legislation well. So thanks.
Good job.
I definitely echo the comments of my co-judges. I thought your prepared remarks were very good. It's clear that you understood the principles, and I think you're the first team that actually went into it. A number of teams have mentioned laboratories of democracy. I loved and you actually said what that was, but I loved your laboratories for discrimination. I mean, that can be a downside to basically some things that are in state constitutions. I thought that you guys did a good job answering our questions. You answered them. You're very responsive. And like Stephen said, you kind of took away some of our questions because you already addressed them in your prepared remarks. You gave good responses to the questions asked. And there were a number of things that were unique with regards to your responses, both prepared and verbal. I thought you did a good job of relating back to the Constitution, and and the distinction between, again, I don't necessarily want to repeat what the other judges said, but being clear on the distinction between constitutional amendments versus state amendments, and the pros and cons with both, and the difficulty involved in amending the Constitution, and the ease of amending state constitutions, which isn't always a good thing. A good job, well done, and good participation by all. So congratulations and good luck.
Good luck.
Thank you.
Yeah, good luck.
Oh, and sorry for being late.